And a question.
Please.
Thank you. First of all, I appreciate the approach you've taken to address the situation. I know you shared with us some of the options that you looked at before landing on this. And I will be supporting the bill. Though I just wanted to see if you have a response to the following. One would imagine there is incentive enough in the real world for these very large corporations to get their act together. I mean, no one wants to be in Target's situation. No one wants to be in the slew of different large operations that have been embarrassed and had their consumer base put in a very vulnerable situation. That's not to suggest we shouldn't do something, which is why I support the bill. To what degree do you think this will up their game? Or do you think that they're struggling because they just have not found appropriately strong defensive technology?
Well, it's a very good question. It's sort of a broad philosophical question, and I think that there's a lot of factors at play in terms of whether the humiliation or the potential loss of customers sort of self-regulates the market. There, you know, and every different store and every different technology is different. You know, if you're like me and you've had one email provider for essentially your adult life, and they get breached, you're not going to say, well, their security is not so good. I'm going to transfer all of my thousands of emails to another provider. So it's kind of hard. Similarly, if you're a lifetime Kaiser Permanente patient, you know, and you've been with them for 50, 60 years, you know, and all of your health records are breached, it's not like there's a fungible market there either, where you can say, well, I'm sick of them, I'm going to go to whoever. So that is one thing that profoundly does not sort of self-police the market and requires a law like this. The second factor is there's this profound generational divide where people of a certain generation are mortified by breaches, they are horrified by them, and people who are born roughly after 1980 are like, it's a fact of life. And that is something that I don't know. I mean, perhaps as people like you and I leave the legislature, because I think we're in the mortified camp, you know, maybe people won't treat these as such a big deal. They'll just treat them as an everyday part of life. But I think that's sad. I think that is a sad statement to say that you know, at some point everybody will have their intimate photos and their correspondence and their health records and everything else, where they went to a bar and took an Uber home, public for the world to see, because every company will be hacked at some point. I think that's a sad statement, and I do think a law like this is necessary to up the game, if you will.
Thank you.
Thanks.
So, move the bill.
Thank you, Senator Leno. Senator Hertzberg.
As amended.
You know, I do think that the business community notion about creating a reasonable standard will invite litigation. I think they're right. People will litigate what constitutes reasonable. What Senator Leno indicates is no one wants these breaches. Nobody wants them. But as you were indicating with the president of Visa, every few seconds there's a hack. There just is, right? And so the question is, what's the role of government in all of this? Does government, is it our role to sit back and say it's going to happen and that we're going to fix it, or do we set a standard? And there will be a series of cases that will come down. There will be a couple of Supreme Court cases that will help support the legislative enactment that will then further define what constitutes reasonable standards that will help further inform businesses. That's what's going to happen over the next 5 or 6 years. And the question becomes, what's our role in government? And I do believe this is the appropriate thing to do, even though it will invite litigation, because if you look at the maturity of policy, this is kind of the way it happens. And it's this or standing silent. And I think, as indicated by the professor, the standing silent doesn't really see the goal, and this is one step along the way, and it will be unfortunate litigation costs in the process. But that's just the way it is, as everybody tries to test what that standard of reasonableness means. So. Certainly will be supportive of your bill today, Mr. Delgado.
Thank you. No, and I agree. And one of the things that we wrestled with, and you know, we talked with a lot of think tanks and a lot of policy experts, is, I mean, some of us remember in the 1980s there was that case of that actress. She was a rather minor actress, but still notably. And yeah, and as soon as DMV records became as soon as DMV records became more ubiquitous and more electronically digitized, there was that stalker who got her address information, and unfortunately he killed her. And then the legislature reacted. Well, most think tanks think it's only a matter of time before somebody gets your fingerprint and does some mischief with it, or even worse, finds out every single, I mean, in certain cities, there's people who live carless and they get around only by ride-sharing companies. And if you know exactly where someone's going to be at 2 a.m. every Friday night, the potential for mischief is profound. I mean, it's profound in terms of knowing what they do, knowing who they're dating, but also where they're going in their path. And that's right, when their home is empty, yeah.
Great, we've
and so,
got a motion.
all right, I will shut up. Thank you.
That's not what I said, but
Well,
thank you.
I'm more than...
Madam Clerk, let's take the roll.
The motion is due pass as amended to the Senate floor. Jackson. Morlock. No. Morlock, no. Anderson. Hertzberg. Hertzberg, aye. Leno. Leno, aye. Monning. Wykowski. 2 to 1.
2 to 1, and put that on call. Thank you.
Thank you very much.
Gatto, we've got you again for another shot with Assembly Bill 139.
We do indeed. And if the sergeants indulge me, I will pass around this the handy-dandy chart. Thank you. Okay, first I want to start by thanking the chair and particularly the committee staff, notably Tara Welch, for their tremendous hard work on this bill. I know you guys have had a very busy week, and we worked to get this one just right. And I also want to take the amendments noted on page 8 and 9 of the analysis. So we are, of course, accepting the amendments in this bill as amended. There are very, very, very few things, in my humble opinion, that the legislature does for the middle class. This, in my humble opinion, of course, it's my own bill, but I think this is the most significant piece of legislation right now for the middle class, for the average middle class homeowner who's sort of the silent masses in California, the people who they're not always subject to the legislature, and we don't often do things for them. Right now, if you own a home, and whether that home is $1 million home or a $500,000 home or a $150,000 home or a $30,000 condo in Bakersfield, you have two ways of passing that piece of property. You can pass it in a will, in which case you're going to face an average of $26,000 in probate fees after you die. Or you can pay an attorney to do a trust. And that trust will cost you between $2,000 and $6,000. There really is no other elegant way to pass that property. Now, if you look at the ways to pass other assets, you have a pension, you have $1 million stock portfolio, you have a Ferrari, you have a bank account. All of these different assets, and if you look at them on the little chart I passed around, you can pass these, which are what are now called, which were originally called Totten trusts. There was a New York case in about 1910 that was the Totten case. And it involved testing the capability to pass a bank account by just specifying a beneficiary so that those funds did not need to go through the probate process, which is more bureaucracy. And of course, since Totten trusts have been adopted, they've been extended by the legislature to things like cars. Right now, you can specify on the back of your pink slip who you want your car to go to when you pass away, and that's everything from your cheap $2,000 car all the way up to your $500,000 classic Ferrari. In response to this bureaucracy reduction, lots of states have adopted what's called a transfer on death deed. Just so that people know that I practice what I preach, I have a small piece of property in Arizona. Arizona passed this law. I was running to get my form and to do this for my piece of property in Arizona. And this is a simple concept that you can file a deed with the county recorder, and it just says, it's akin to a quitclaim while you do it, you're alive, but you file it with the county recorder, you have all the protections. It's notarized, it's witnessed, all these things. You file it with the county recorder sends a piece of mail to you saying, did you intend to file this? Yes. And when you pass away, that property passes to your heirs. You avoid probate, you avoid having to pay for a trust. This bill would implement this in California. We would become the 26th state in the union to do it. I think the time has come. I think this bill has now, after the committee amendments, just a tremendous amount of protections, in here for the bill. It's supported by AARP, the Howard Jarvis Taxpayers Association, and a lot of people out there, middle-class people who want the government to do something for them, and I respectfully ask for your aye vote.
Thank you. And your two witnesses.
Good afternoon, Senators. I'm Brian Hebert. I'm the Executive Director of the California Law Revision Commission. This bill is based on a commission recommendation that was prepared pursuant to a statutory assignment to the commission to study this topic. I don't have any prepared remarks today. I'm just available to help answer any questions you might have.
Perfect. Next.
Yes, Mr. Chairman, just briefly, David Wolf, because I don't want to take away from Mr. Doyle, who is far and away the expert on this bill. David Wolf with the Howard Jarvis Taxpayers Association. We're in support, obviously, and we've been in support for 7 years on 5 different versions of this bill. And I would just like to say that among our board of directors, other than Prop 13, there's no greater bill that we support than this one this year. Ask for an aye vote.
Thank you, Mr. Wald.
Larry Doyle on behalf of the Conference of California Bar Associations. The conference has been a supporter or co-sponsor of at least 3 of the previous pieces of legislation that have been introduced in this area. And quite frankly, we think that this is the best of the group because we have a good author who has been able to get people to the table. We've been able to work with the opposition to address concerns and to make it a much stronger, more protective bill to make sure that it is less subject to the kind of abuse that every estate planning instrument is subject to. Again, I practice in this area, and quite frankly, if I was going to engage in elder financial abuse, I would not use a revocable transfer on death deed because there are a lot better things that you can use to cheat. But I think that this is this bill, to the extent that there were any problems before, has been substantially improved. Worked with the Trust and Estate section of the State Bar, the Land Title Association, the assessors, and I think that with that and the assistance of committee staff, which has further tightened the bill, I think that it is a very good bill, and I think that I hope the committee will support it. Thank you.
Thank you, Mr. Doyle. Any other witnesses in support?
Senior Senator Lola Young with the California Senior Legislature, and we are in support of this bill.
Anyone in opposition? Oh, thanks. What a fake. Okay. Fake me out. Okay, then any discussion? Senator Leno, any questions? Have a motion? I have a motion. Why not go ahead and call roll?
The motion is to pass as amended.
Wait. I should ask for closing comments.
I ask for a aye vote.
Thank you.
The motion is to pass as amended to Senator.
That's too late. Go ahead and call the roll.
The motion is to pass as amended to Senate Appropriations Committee.
I'm sorry, Madam Clerk. He's serious.
And I recognize that we saw no opposition here today. Do the amendments impact the California advocates for nursing home reform? Do we know, or do we know where they are? Do they still have concerns?
You know, I did not want to wade into that controversy. My bill does not. My bill just says to the extent permissible by law. So my bill does not weigh in on that. It's agnostic. I'm not going to take on that battle. There's other bills pending. The governor vetoed one last year. My bill has nothing to do with that. So,
This bill does attempt to address the concerns raised by the canner by simply saying that the property that is transferred by a revocable transfer on death deed is subject to Medi-Cal reimbursement to the extent provided by law. And so, again, that's...
So if the legislature does away with that, then, you know, my bill's agnostic. So it's the extent that it's authorized by law. So.
Thank you for that.
Sure, thank you.
Madam Clerk, go ahead.
The motion is to pass as amended to Senate Appropriations Committee. Jackson. Morlock.
Aye.
Morlock, aye. Anderson. Hertzberg. Leno. Leno, aye. Monning. Wachowski. 2-0.
Thank you very much.
0 on call. Thank you very much, Assemblyman Gatto. That takes us to Assemblyman Nazarian with item number 5, AB 551. Welcome.
Thank you, and good afternoon. This is hopefully going to be a very straightforward, simple bill. AB 551 establishes procedures and protocols consistent with the National Pest Management Association best practices for tenants and landlords to eradicate bed bug infestations and make sure that they are dealt with in a cooperative and expedient manner. Specifically, this bill establishes various notification requirements for both landlords and tenants and requires the initiation of a bed bug management plan in the event of a bed bug infestation. Bed bugs continue to be a major challenge for many California Californians. The requirements under this bill will ensure that landlord and tenants work together to eradicate and prevent bedbug infestations. I have worked with supporters and opponents of this bill. I believe that this bill and the amendments taken in committee today strike a reasonable balance for all stakeholders. These amendments make minor changes for notification requirements and make clarifying changes to the existing provisions of the bill to ensure smooth cooperation. With me, I have Anya Lawler with the Western Center of Law and Poverty and Heidi Palutke with the California Apartment Association.
Good afternoon, Mr. Chair, members. Anya Lawler on behalf of Western Center on Law and Poverty. We are pleased to be a co-sponsor on this bill. I briefly want to just stress 3 key points about bedbugs. First, bedbugs are a growing public health problem. Infestations have risen dramatically in California and nationwide in recent years. In fact, Los Angeles now ranks 2nd in the nation in terms of bedbug infestations. Second, bedbugs are not picky eaters, and unfortunately, we are their food. They don't really care how much money you make, how nice your home is, or how good or bad your housekeeping skills are. They only care that you're alive, and once they move in, they're likely to bring their entire extended family along for the free meals. Third, they are very, very difficult to eradicate. Getting rid of bedbugs isn't as simple as spraying a can of Raid. Effective treatment requires help from a trained professional and cooperation from both landlords and tenants. This bill establishes a framework for addressing bedbugs in rental housing that recognizes the rights and responsibilities of all parties in dealing with infestations. It comes out of a working group in Los Angeles that involved a wide range of stakeholders, including both landlord and tenant groups. It definitely doesn't address all possible issues with bedbugs, but it does represent the points of greatest consensus among the stakeholders that participated in that group. We're definitely pleased to have our partners at the California Apartment Association in support of the bill, and we believe it's a really good starting point for reducing the incidence of bedbug infestations in California. And with that, I respectfully ask for your aye vote.
Ms. Lawler? Ms. Palutke?
Good afternoon. Heidi Palutke on behalf of the California Apartment Association. This bill would create a very reasonable framework that would make it possible for rental property owners, managers, and tenants to work together to prevent and control bedbug infestations in residential rental property. Unlike a lot of other habitability issues, it's not so easy to determine fault in the case of bedbugs. Is a tenant really at fault if they happen to pick up a bedbug or two in a movie theater? Is the owner really at fault if a maintenance worker happens to pick up a bedbug or two in the cuff of his pants and BART on the way to work? Because this is so different, this is really the reason why the Apartment Association is supporting this bill. It does contain enforceable duties for tenants and for landlords. Landlords who do all the right things and who meet the reasonable deadlines in the bill receive some protections. Once they've contracted with a pest controller to do the work in accordance with the National Pest Management Association guidelines, if they are jumping through all those hoops, they are protected from claims of habitability and substandard housing related to bed bugs. The bill strikes a reasonable balance between the needs of landlords and tenants, and if enacted, will definitely help reduce the bed bug population throughout California, which we all certainly want. It would place California at the forefront of the nationwide fight against bed bugs. For these reasons, we ask for your yes vote today.
Good afternoon, members. Brian Augusta on behalf of the California Rural Legal Assistance Foundation, one of the co-sponsors of the bill. And we have key tenant groups and key landlord groups here at the table supporting the measure. We've been working very hard to deal with remaining concerns from other organizations, and we are, I think, very happy with the product that is before you, but the conversations continue, and we hope that we will have an aye vote. Thank you.
Thank you. Assemblyman Nazarian, just for the record, you're presenting this with the amendments that were submitted?
Yes.
Okay, great. And then are there any other witnesses in support?
Vanessa Hina on behalf of the Mosquito and Vector Control Association of California here in support.
Any witnesses in opposition?
Mr. Chairman, members of the committee, Ron Kingston. I represent 5 apartment associations today: Apartment Association Orange County, Apartment Association, California Southern Cities, East Bay Rental Housing Association, NorCal Association, and North Valley Association. We have been working, excuse me, steadily with the author and sponsors throughout the course of this legislation. While we're very appreciative of the progress that has been made, there are 4 issues that remain, which we, as a consequence, are asking for an opposed position or no position of the committee. They're as follows. The first appears on page 5, 1954.12, dealing with, and this addresses the issue of notice. This notice anticipates this general notice that would not only be going to and distributed to every lease and every new lease in the state for residential housing, but it contemplates that we are to distribute this same notice to every tenant, every household in the state of California. We anticipate that would be 6,000 reams of paper plus envelopes if we are to mail it plus mailing. There is no precedent in history, including lead-based paint and other types of potential hazards that occur on the property. There is no other requirement in law that requires us to distribute a notice on any other bed, bug, or type of insect whatsoever to all existing tenants. Given that we have 39 million people in the state of California, we have a 60% roughly owner occupancy ratio for owner-occupied property. The rest are tenants. This is an incredible burden. We don't mind distributing this general notice to the new tenants, just existing tenants. It is a substantial burden, and it is not demonstrated that that has been needed. The second issue—
You've got 2 minutes. And
okay, I'm trying to do it.
The other speaker do the other 4 points then?
And I'll go much faster.
Okay.
Mr. Chair.
That'd be a good idea.
The second issue, while we talked to committee and the author's office, appears on point 14, page 6, and of the mock-up. In 5 business days, we are not only to—
what I would recommend, Mr. Kingston, is you just give us the points, not all the detail.
All right. In 5 business days, we are to provide not only in contract with the pest control operator, but we are to have that inspection done of the property that we just can't achieve. We think the intent
is, and point 4 is.
Okay, point 3 is we are respectfully requesting the bill to be amended and to require the tenant to give us notice as within 24 hours if they need to delay the treatment. That's only reasonable, and it would be the most practical solution. And the 4th point deals with extension of time. We have repeatedly asked if any tenant wants to extend the treatment period by 3 days, that to apply universally, not only to the disabled, but also to every tenant. This bill doesn't do that. It leaves it very unclear in terms of what we are to do with the disabled community and how we respond to them, and then all other tenants. It would be much clearer to do it one time and have every tenant. 4 points. Those are our 4 issues.
Thank you, Mr. Kingston.
Thank you.
Mr. Chair and members, Pat Moran with Aaron Reed and Associates representing the San Diego County Apartment Association. We just have one concern left with the bill. Appreciate the amendments that the Assembly members taken, and that's with 1954.16. Our client provides a management plan to their tenants already with regard to bed bugs. They're members of the National Apartment Association, which has developed the Bed Bug Resource Center. That's where we get our best practices on how to treat bed bugs, how to what the tenants' rights are and what their obligations are. We provide that as an addendum to the lease to the tenants, and we don't think that we should have to develop and pay for a bed bug management plan if one already exists. I've talked to the sponsors. to the bill, and they're willing to work on that with us, and I think we can come to some sort of conclusion, but that's our sole outstanding issue at this point.
Thank you. Are there any others in opposition? Seeing none, you want to make closing comments? Please, thank you, Senator.
On this last point, if I'm reading this right, it says no later than 30 days after a bedbug infestation is confirmed by a pest control operator. So for the San Diego apartment folks, once you have the first infestation and you develop the management plan, then you're out. They would have to do one more management plan. I assume that if they've got a management plan, I don't know about managing bed bugs, but once they do it, I think, would they not be in compliance with 1954.16? January 2nd.
We would agree with that, but if the language needs to be a little more clear, we can probably accomplish that.
The other question I have is on the question raised. We make a distinction between the inconvenience of somebody who's disabled, who needs a little bit more time, and don't distinguish between somebody that just needs more time. Obviously, if you have bed bugs, any delay is a bad delay. I get that. Is there?
The tenant can ask for extension. This was never meant to be a hard line or hard set date. The idea of the bill was to ensure that there are responsibilities both by landlords and tenants, so that we can address the issues between them prior to it going to the court, because that's where most of these issues were being settled.
Right. So it's your intent that you got a fourplex or a sixplex, and you got to do the whole place. You're just trying to get everybody together and saying, okay, it's Tuesday at 9, we're doing it, right? Is that? Or
yes, but the bill does allow anybody to ask for an extension of time.
Okay.
It just doesn't specify what time has to be granted.
Are there any other witnesses here? We've had both the support. Any opposition come forward?
I'll move the bill.
All right, there's a motion if you would like to close.
I just respectfully ask for a vote.
Ready? Well done. All right, Madam Secretary, this is due pass as amended to the Senate floor.
Jackson?
Aye.
Jackson, aye. Morlock? No. Morlock, no. Anderson? Hertzberg? Leno? Monning? Wykowski?
Aye.
Wykowski, aye.
You have 2 votes. We'll put that on call. Sorry, I couldn't have heard more of the discussion, but thank you very much for your presentation.
Thank you.
All right. Who's here? Gibson, okay. Where's Hernandez?
He's not here.
He's not, okay. Let's go then to file item number 7, AB 709 is next up. Is the Assembly member here? Assembly member Gibson? If that's your pleasure, then I have no problem with that whatsoever. Very good. All right. No problem. We'll start then. We'll go to file item 8, AB 883. And good afternoon, Assemblyman. And please, 2 witnesses in support.
Great. Thank you, Madam Chair and Senators, and I appreciate the courtesy of my colleague. AB 960 would update California's assisted reproduction statutes to ensure that all families are equally protected.
Excuse me. My apologies. I misspoke here. We're in file item 9, not 8.
Correct.
My apologies. AB 960. Correct. Assemblyman, please proceed.
Thank you again. AB 960 would update our state's assisted reproduction statutes to ensure that all families are equally protected under the law. Currently under family law, unmarried couples that are using assisted reproduction with a donor as a parent are not recognized as parents, even though many unmarried couples conceive children in this way. Additionally, current law requires couples to use costly sperm banks and doctor oversight, or else a donor could be considered a legal father. Many parents, gay or straight, use at-home insemination because they can't afford to use a doctor or a sperm bank, which often costs thousands of dollars per month. The parental rights of these couples are unclear, and their donors are at risk of being required to pay child support. AB 960 would establish clarity for these donors and intended parents that are using assisted reproduction, as well as provide clear direction for how egg donors should be treated. I have two witnesses today. I'd like to turn it over to the National Center for Lesbian Rights and then from a family who will provide their personal story.
Very good. Thank you, Assembly Member. First witness.
Thank you, Chair and members. My name is Kathy Sakimura, and I'm the Family Law Director at the National Center for Lesbian Rights. At the National Center for Lesbian Rights, we receive hundreds of calls from families who are conceiving their children through assisted reproduction. And a large number of these calls are coming from families who are doing at-home insemination because they just can't afford the cost of using a sperm bank or a doctor to assist them with the conception. We also receive many calls from unmarried parents who are using assisted reproduction to conceive. Unfortunately, we have to let these families know that they're currently unprotected by California law, and that they have to wait until after their child is born to take any steps to protect their families. This means that for parents using at-home insemination, their donor is potentially a legal parent until they are able to complete an adoption that terminates his rights months after the child is born. And for unmarried parents, the non-biological parent is not able to get on the child's birth certificate and may be unable to put the child on their health insurance. AB 960 brings California law in line with many states in the national trend that recognized that people using at-home insemination should be protected, as well as unmarried couples, and they should have the same protections that are provided to other families using assisted reproduction. Thank you for your consideration. We urge your aye vote.
Thank you very much. Witness.
Good afternoon, Chair Jackson and committee. Thank you. My name is Mary Northup, and this is my wife, Andra, and my son, who's my eldest son, Matt. Andra and I have been in a committed relationship for 31 years. We were married in 1984 in a ceremony performed by Andra's brother, who is a Presbyterian minister, and that he decided that even though the church at the time, nor the law, would recognize our marriage, he wanted to officiate a ceremony to sanctify it in the presence of about 70 of our friends and family. After much discussion and great consideration, we decided to try to start a family in late 1987. Out of concern that our children might wonder about the identity of their genetic father, we decided that we would ask friends if they would be willing to help. We got positive responses from 2 sperm donors. Initially, we used only one, but as Andra had difficulty conceiving, we used donations from both. We ended up going to a fertility doctor who felt that Andra would be much better off if we continued trying to conceive with fresh semen. He worked at UC Davis. At the time, in the late 80s, there was a restriction that he had to use frozen if he handled the semen. He didn't feel she would conceive. So, unbeknownst to us, this left Andra, as a legally single woman, open to a paternity action, and our parental rights, they weren't assured or protected by the state, given the method that we used to conceive, at our doctor's suggestion. In our naivete, it never occurred to us that we or any children born to Andra would be at financial or emotional risk. Late in Andra's pregnancy, one donor did indicate that he might make legal demands. Our son was born in 1990, and when he was 6 weeks old, the scenario that we feared happened. We received notice of a paternity action by one of the donors. We consulted an attorney, which was not a very easy thing to do because no attorney wanted to represent us as a family. We weren't a family. I had no legal standing. They were very concerned about having me even in the room when they were consulting with the mother. We finally did find a lawyer who was willing to represent us, seeing us as a family, and then she wrote a letter saying we were willing, we had never intended to deny rights, or even, that was the whole point of using a known donor, but this concept of going through a paternity action was going to be very difficult. So the one thing we asked was that he recognize my right as a parent, which he refused. We ended up in a long, protracted legal battle. In Yolo County, we found ourselves in front of a judge that berated us as lesbians for having a child as a plaything. The judge threatened to remove our son from our household if we did not give in to every demand that the sperm donor father made.
Can I apologize for interrupting you. It is my hope, having practiced in the family law arena back then, that things have improved dramatically since then. So let us assume that they have. If you could just give us, if you would, the last paragraph or two on why you think this bill is helpful, and congratulations for your persistence.
Well, I will tell you, I was not able to legally adopt my son until 2 years ago when he reached the age of majority, right? Okay. Up until that point, I at least was observed as a step parent, even though we could not be legally married. So while you want to say things are wonderful, I guess I was able to finally be a family with my son and my wife and my younger son, who we did not use a known donor for. For the last 2 years, we've been a family. That's been the lucky thing. But all this time, I've supported my son emotionally, financially, without the benefit of that legal recognition. You know, so. It's striking to me that I could plan a family, that I could support a family, that I could have a family for so many years, and only now be legally recognized as part of that family. Frankly, only because we could be legally married in that narrow window in 2008 was I able to adopt my son 2 years ago, or the mother would have been taken off the birth certificate when I adopted him. Okay.
So hopefully this bill will help on the issue before us, and that perhaps there's more that we can do so that this kind of situation doesn't happen any further. And,
thank you.
All right. With that, thank you very much for your testimony. Are there any other witnesses in support of this measure? If you just step forward, name and affiliation, and obviously in support of the bill.
Joe Michael for Equality California. We're proud to co-sponsor this bill and urge the committee's support today. Thank you.
Thank you. Anyone else in support? Please, if you'd step up, all of you. This hearing is moving not as quickly as it should. So if you'd come on up and give us your name and affiliation, please.
Rita Bolin, Our Family Coalition. We are in support.
Thank you.
Becca Kramer, ACLU of California, in support.
Thank you very much. Next witness.
Hi, Shannon Smith-Crowley for the American Society for Reproductive Medicine, in support.
Thank you. Any other witnesses in support? Is there any opposition? All right, seeing none. Senator Morlock, any questions? I just want to thank you. I appreciate the importance of this bill. I think the really important aspect of this bill is the importance of people knowing what their expectations are and should be, because having a child is probably the most important decision that one makes. So this bill, I think, will give some clarity to a situation that definitely needs it. And with that, I would seek a motion moved by Senator Wojtkowski. Assemblyman, if you'd like to close.
I respectfully ask for your aye votes. Thank you.
Good. Thank you very much. And thank you for being here. All right. We have a motion due pass to the Senate floor. Madam Secretary, please call the roll.
Jackson.
Aye.
Jackson, aye. Morlock. Anderson. Hertzberg. Leno. Monning. Wojtkowski.
Aye.
Wojtkowski, aye.
We have 2 votes. We will have the rest of our committee hopefully returning shortly.